Please like this video and subscribe to the channel.
As you may have heard, the Supreme Court here in America issued a critical decision regarding whether or not former President Donald Trump can be placed on the ballot in Colorado for the forthcoming federal
Republican presidential primary elections.
Of course, as a lawyer, I read the decision. I found it to be very interesting, and I'd like to share on here today with you what I have learned. Before we get into it, as always, I'm going to ask you to please subscribe if you're not already a subscriber, and hit the notification bell if you want to be notified every time I upload new content. I would also ask that if you find this video to be informative, please click that thumbs up button and feel free to share the video with others who you feel would enjoy hearing what we're going to discuss here today. This is not a political video for me. This is a legal video in which I examine a case that has come before the court, take a look at the decision that the U.S. Supreme Court issued, and talk about and explain what that decision is and how the court arrived at it. Just an initial disclaimer. Okay, so the case is called Trump v. Anderson. That's Donald J. Trump versus Norma Anderson et al. Norma Anderson and the other respondents are Colorado voters who filed suit in a Colorado state court. They were alleging that under Section 3 of the 14th Amendment to the U.S. Constitution, Donald Trump is disqualified from running, or really not even from running, that Donald J. Trump is disqualified from holding office as president again because he engaged in an insurrection. So, the Colorado State Supreme Court agreed with the voters, and they ruled that Donald Trump is disqualified from holding the office of president again, and they ordered the Secretary of State in Colorado to remove Donald Trump's name from
the Republican primary ballot
and to ignore any write-in votes for Donald Trump. Okay. So Donald Trump appealed to the U.S. Supreme Court, and the Supreme Court took on the case. Let's look at what the statute is, or rather what the constitutional provision is, how the Supreme Court analyzed the case, and why they ended up ruling in favor of Donald Trump. I will keep my opinion to myself until the end. Let's just get into it. Okay, so let's start at the logical starting point, which is to look at Section 3 of the 14th Amendment to the U.S. Constitution, which is essentially where the U.S. Supreme Court started as well. It's a long provision, so I'm going to read it to you now. It says that no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state, to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same, or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such disability. So It's basically saying, in so many words, that if you held certain offices at the federal level or at the state level, and you took an oath as a part of that office to defend the Constitution of the United States, but after that point in time, you subsequently engaged in insurrection or rebellion against the United States, or gave comfort or aid to the enemies of the United States, then you are thereby disqualified from holding certain federal offices. So the Colorado voters said that that section disqualified Donald Trump from holding the office of president again, because after he lost the last election to Joe Biden, he organized and incited an insurrection that involved the breaching of the Capitol on January 6th, when the members of Congress were trying to confirm that Joe Biden indeed had been elected, and that he did so in an attempt to retain power. And their further argument was, because of that disqualification, Donald Trump could not be placed on the ballot in the state of Colorado. So the district court in Colorado, which is the trial court at the state level, ruled that Donald Trump had indeed engaged in an insurrection, as specified in Section 3 of the 14th Amendment. However, that court ruled that the office of the presidency is not specifically listed in Section 3, and that the presidency is not an office of the United States, and the president is not an officer of the United States. So the plaintiffs lost. The court ruled that Section 3 does not prohibit Donald Trump from being on the Colorado state ballot. Okay, so the Colorado voters appealed to the Colorado Supreme Court, and that court decided to take the case on. That court affirmed the trial court's ruling that Donald Trump's actions in connection with January 6th constituted an insurrection under Section 3 of the 14th Amendment. However, the court reversed the district court on the part about whether or not the presidency is an office of the United States and the president is an officer. And as a result, they ruled in favor of the voters. Again, they ruled that yes, Donald Trump engaged in an insurrection, and that because he was an officer of the United States under Section 3 of the 14th Amendment, he was disqualified from holding the office of president again and could not be placed on the Colorado ballot, right? So they ordered the Colorado Secretary of State to remove Donald Trump from the Republican primary ballot and to disregard any write-in votes for him. Well, President Trump petitioned the United States Supreme Court to challenge that ruling by the Colorado State Supreme Court, and the U.S. Supreme Court decided to take on the case. Now, just a brief note here. In a case like this, the United States Supreme Court has the option to hear the case or not to hear the case. And in this case, they chose to hear it, granting Donald Trump's petition for certiorari. Probably a legal term nobody here needs to know. Just means that, yes, they decided to hear the case. And it is significant to note that Donald Trump's petition raised one issue and one issue only. Did the Colorado Supreme Court err in ordering Donald Trump excluded from the 2024 presidential primary ballot? And that is the issue that the Supreme Court decided in the opinion that it released today. And it held that, yes, that state Supreme Court did so err, and it reversed the Colorado Supreme Court's decision. It is significant to note that the Colorado Supreme Court ruled in favor of the Colorado voters in a 4-3 split decision, with 4 of those state Supreme Court justices ruling for the voters and 3 dissenting or ruling against them. But of course, the majority carried the day. What's significant about this Supreme Court decision is that it's issued per curiam, which means that the entire court unanimously agreed on the outcome. Now, there were some concurring opinions, which is when a Supreme Court justice doesn't agree fully with the reasoning that was used to reach the decision, but they agree with the decision. And that's what we have here. All of the justices agree with the decision in that opinion that they issued today. And I find the process by which they reached that decision, their analysis, to be very interesting. Let's take a look at it. So there are some legal intricacies in the opinion that I am not going to go into because I think that they would just be overly boring, make the video overly complicated and difficult to follow, and they're not necessary for my viewers to get the understanding of how the Supreme Court analyzed the issue raised and reached the decision that they reached. So I'm going to go into only as much detail as I think is necessary to make sure my viewers get the point. And then anything else that's overly legal or overly technical, I'm just going to breeze by it because it's not relevant and it doesn't change anything. So the Supreme Court essentially did a historical analysis of Section 3 of the 14th Amendment to the U.S. Constitution, looking at when it was passed, what the purpose for passing it was, how it was implemented or utilized once it was passed, in order to determine whether the ruling by the Colorado State Supreme Court was erroneous or wrong. And we already know that they reversed it. So the United States Supreme Court first started off by noting that the purpose of Section 3 of the 14th Amendment was to ensure what they called an enduring union. In other words, to ensure the continued existence of the United States by preventing former Confederates from returning to power in the aftermath of the Civil War. So again, the court really delved into the historical purpose of Section 3. And the court explained that Section 3 operates by imposing on certain individuals a severe and extreme penalty, which is disqualification from holding a wide variety of offices. And so the first step in their analysis was to determine which individuals are included in Section 3. The Supreme Court held that the United States Constitution empowers Congress to prescribe how those determinations are to be made. And in doing so, the Supreme Court pointed to Section 5 of the 14th Amendment, which empowers Congress to pass appropriate legislation to enforce the 14th Amendment. And then the Supreme Court took a look back at what was going on after the passing of the 14th Amendment. They noted that a Senator Trumbull, who was in office back in the late 1860s, was complaining that hundreds of men were holding office in violation of Section 3 of the 14th Amendment. And this Senator Trumbull was saying that because the Constitution did not provide a method for enforcing Section 3 of the 14th Amendment, a bill was required in order to do that, in order to get those people who should be disqualified from office out of office. And as a result, Congress ended up passing the Enforcement Act of 1870, which included, among other provisions, a method for enforcing the disqualification from office of Section 3. The court then noted that a fundamental issue that's raised by this case is whether the states, in addition to Congress, have the authority to enforce Section 3 of the 14th Amendment. What the court ruled was that the states may disqualify persons holding or attempting to hold state office, but that the states have no authority to enforce Section 3 when it comes to federal offices, and particularly to the presidency. And then the court just noted, like in America, we have a system where all the power really is reserved to the states, except for the specific powers accorded to the national or federal government under our Constitution. So prior to the enactment of the Constitution, the states had authority to make decisions about who could hold or run for state offices, and they retained that authority, the Supreme Court says, even after the passage of the 14th Amendment and the Enforcement Act for that amendment. And then continuing to look back historically, the court noted that after the passage of the 14th Amendment, the states continued to use their retained authority to govern who could hold or run for state office in accordance with state statutes. So they relied on state statutes to do things that they had done prior to the 14th Amendment. But the court noted that that retained power by the states did not extend to federal officers, because when it comes to federal offices, there is no retained authority by the states. The states have to be specifically granted or delegated authority. And that did not happen in this situation. The Supreme Court made clear that the United States Constitution guarantees the entire independence of the federal government from interference by the states. The Supreme Court noted that the 14th Amendment granted certain specific powers to Congress and limited the powers of the states. Remember, the 14th Amendment is famous. It's the one that prohibited or prevented states from depriving anybody of life, liberty, or property without due process of the law, and entitled everyone to so-called equal protection of the law, and that sort of thing. So the 14th Amendment specifically and significantly limited the power of the states and granted Congress certain new powers. And the Supreme Court was like, and that whole fact is inconsistent with the notion that Section 3 of the 14th Amendment granted to the states the power to regulate who could hold federal office or who could run for federal office. The court took another look back historically and noted that there were no instances where a state had prevented a federal candidate from running for office or disqualified and removed a federal office holder. Then the court went back again historically to note that it is indeed Congress that has, over a long-standing period of time, enforced Section 3 of the 14th Amendment, the court noted that the Enforcement Act of 1870 empowered federal district attorneys to file civil suits in federal courts to remove any federal non-legislative officers who were holding office in violation of Section 3, and that the Enforcement Act actually made attempting to hold federal office in violation of Section 3 a federal crime. So all the way around, the history of this Section 3, why it was enacted, and how it was utilized after it was enacted, pointed to the fact that authority to enforce Section 3 with regard to federal offices and candidates was reserved to the federal government, namely the U.S. Congress. And then the U.S. Supreme Court got to the really obvious point. If each state is allowed to regulate whether or not a person is qualified to run for federal office, the office of the presidency in particular, there's no guarantee that every state would reach the same conclusion. They have different state statutes, different ways of enforcing those. So the same candidate, based on the same conduct, might be eligible to run for presidency in certain states based on those state statutes, but would be ineligible to run for president in other states because of those states' statutes. Of course, that would be an unreasonable result. And the court specifically stated that nothing in the Constitution requires us to endure such chaos. And it's significant to note that in this opinion, the U.S. Supreme Court specifically mentioned the state of Maine, which had also removed Trump from the primary ballot. So this decision overturns that action by the state of Maine, and they must add Donald Trump back to the presidential primary ballot. Because in America, the United States Supreme Court rulings are the supreme law of the land. Any state opinions or actions that contradict the rulings of the Supreme Court are no longer valid. The actions must be reversed. The opinions are specifically reversed by the opinion issued by the United States Supreme Court. And the Supreme Court concluded by saying, for all those reasons, they hold that the right to enforce Section 3 of the 14th Amendment resides with Congress and is not granted to the states. And for that reason, they reversed the Colorado State Supreme Court. And the Supreme Court ended by making a point of the fact that all 9 justices of the Supreme Court agree with this ruling, even if they would have reached the ruling on different grounds or don't agree with every single ground that is mentioned in the opinion. All of them agree that this right to enforce Section 3 of the 14th Amendment to determine who is disqualified from holding federal office, and the office of the presidency in particular, is a right that can only be enforced by the United States Congress, and the states have no control over that. So I found the Supreme Court's decision in Trump versus Anderson to be very interesting to read, to be logically consistent, and to be a proper analysis. It is right on point with how lawyers in this country are trained to interpret the Constitution and federal statutes. We look at the historical purpose for why a particular statute or provision was enacted. We look back at how that statute or provision has been enforced over time, and we use that historical information to help arrive at a conclusion today. In America today, people are up in arms. Trump supporters are celebrating and heralding this as a victory like no other, while Trump opponents are just appalled and feel like the court is on Trump's side and has issued a ruling in Trump's favor. As a lawyer, I can say that, in my opinion, the Supreme Court conducted a really good analysis and reached the only logical decision given all the circumstances in this case. There are some other things, however, that makes one wonder if the Supreme Court is actually trying to assist Trump in being able to be involved in this election.
So we see the court issued this decision the day before Super Tuesday when multiple primaries were being held. And
former President Trump has been charged with an array, like 90 plus charges, and there are 4 criminal trials against him. Trump's position is that as a former president, he is legally immune from suit in connection with his activities. Mainstream media is pointing out that Donald Trump's main strategy with regard to those 4 criminal trials is to delay so that the elections can be held. If he wins, of course, he can appoint an attorney general who has authority to dismiss the charges against him. The appeals court in the DC circuit has ruled actually in February, the month we just left, that Donald Trump is not immune from prosecution in the 4 criminal trials. But the Supreme Court has now decided to take up that case as well. And so that introduces delay in terms of when those criminal trials can be held, because they can't move forward until the Supreme Court issues its ruling. If he's immune, the cases have to go away. And if he is not immune, the cases can move forward. But mainstream media feels for sure that the Supreme Court's decision to take up the case and the timing of when it decided to do so basically plays right into Trump's delay tactics. I'm going to show you a couple of headlines from news articles. Even The Guardian, which is a UK paper, has expressed its opinion that the way the United States Supreme Court has moved with regard to Trump's immunity claim has ultimately the purpose of delaying those criminal trials against Trump. Jack Smith, the special counsel prosecuting those cases, came to the Supreme Court back in December and asked them to issue a quick ruling on the immunity issue, but the court declined. And then in February, when the United States Court of Appeal for the DC Circuit held that Trump is not immune, Jack Smith came back again and asked the court to issue a ruling on the matter. And then the court delayed like 2 weeks in even responding. And even though the matter is set for relatively quickly, which will be in April, even after that issues, there's no way really for those criminal trials to be concluded before the November elections. So even that foreign news outlet is saying that the way the court moved would appear to have contributed to delaying the criminal trials until after the November elections. And they ask a real valid question. If the court was going to take up the issue anyway, why all the delays? I don't have the answer to that, but I definitely will keep an eye open to be aware of what the court rules with regard to immunity and what that means with regard to the criminal trials against this former president.